With us today for the first hour are Jordan B. Peterson, Professor, Psychology Department of the University of Toronto, and from the D. Jared Brown Professional Corporation, D. Jared Brown, Lead Counsel. Thank you, gentlemen, for being here. You both have up to 5 minutes for opening statements, and Mr. Peterson, I believe you're going to lead off, Professor. The floor is yours.
So I think the first thing I'd like to bring up is that it's not obvious when considering a matter of this sort what level of analysis is appropriate. If you're reading any given document, you can look at the words or the phrases or the sentences or the complete document, or you can look at the broader context within which it is likely to be interpreted. And when I first encountered Bill C16 and its surrounding policies, it seemed to me that the appropriate level of analysis was to look at the context of interpretation surrounding the bill, which is what I did when I went and scoured the Ontario Human Rights Commission web pages and examined its policies. I did that because at that point the Department of Justice had clearly indicated on their website in a link that was later taken down that Bill C16 would be interpreted within the policy precedents already established by the Ontario Human Rights Commission. So when I looked on the website, I thought, well, there's broader issues at stake here, and I tried to outline some of those broader issues in the initial. You may or may not know, I made some videos criticizing Bill C16 and a number of the policies that surrounding it. And I think the most egregious elements of the policies are that it requires compelled speech. The Ontario Human Rights Commission explicitly states that refusing to refer to a person by their self-identified name and proper personal pronoun, which is the pronouns that I was objecting to, can be interpreted as harassment, and so that's explicitly defined in the relevant policies. So I think that's appalling, first of all, because there hasn't been a piece of legislation that requires Canadians to utter a particular form of address that has particular ideological implications before, and I think that it's a line that we shouldn't cross. Then I think that the definition of identity that's enshrined in the surrounding policies is ill-defined and poorly thought through and also incorrect. It's incorrect in that identity is not and will never be something that people define subjectively, because your identity is something that you actually have to act out in the world as a set of procedural tools, which most people learn, and I'm being technical about this, between the ages of 2 and 4. It's a fundamental human reality. It's well recognized by the relevant, say, developmental psychological authorities. And so the idea that identity is something that you define purely subjectively is an idea without status as far as I'm concerned. I also think it's unbelievably dangerous for us to move towards representing a social constructionist view of identity in our legal system. The social constructionist view insists that human identity is nothing but a consequence of socialization, and there's an inordinate amount of scientific evidence suggesting that that happens to not be the case. And so the reason that this is being instantiated into law is because the people who are promoting that sort of perspective, or at least in part because the people who are promoting that sort of perspective know perfectly well that they've lost the battle completely on scientific grounds. It's implicit in the policies of the Ontario Human Rights Commission that sexual identity, biological sex, gender identity, gender expression, sexual proclivity all vary independently, and that's simply not the case. It's not the case scientifically, it's not the case factually, and it's certainly not something that should be increasingly taught to people in high schools, elementary schools, and junior high schools, which it is, and it is being taught. I included this cartoon character that I find particularly reprehensible, aimed obviously at it as it is at children somewhere around the age of 7, that contains within it the implicit claims, as a consequence of its graphic mode of expression, that these elements of identity are first canonical and second independent, and neither of those happen to be the case. I think that the inclusion of gender expression in the bill is something extraordinarily peculiar, given that gender expression is not a group, and that according to the Ontario Human Rights Commission, it deals with things as mundane as how behavior and outward appearance such as dress, hair, makeup, body language, and voice, which now, as far as I can tell, open people to charges of hate crime under Bill C16 if they dare to criticize the manner of someone's dress, which seems to me to be an entirely voluntary issue. So I think that the Ontario Human Rights Commission's attitude towards vicarious liability is designed specifically to be punitive in that it makes employers responsible for harassment or discrimination, including the failure to use preferred pronouns. They have vicarious liability for that, whether or not they know it's happening, whether or not the harassment was, and whether or not the harassment was intended or unintended. And so I'll stop with that.
Thank you, Mr. Brown.
I'm a litigator in Toronto. I act in all manner of commercial and employment disputes. I'm not an academic. I live with my clients in the land of legal reality and how the law actually works. About 2 years ago, I began to see claims of discrimination included in every employment-related court claim. My phone now rings weekly with human rights tribunal matters. It has become a reality for employers across Canada. In August of last year, I became aware of Dr. Jordan Peterson. He was discussing what he saw as a problematic law, poorly written. That's when I observed the oddest thing happening. Lawyers, academic lawyers, important people began to say that he had the legal stuff wrong. Nothing unusual about this bill. And they also said, you don't get to go to jail if you breach a human rights tribunal order. What was happening is they weren't defending the law, but downplaying its effects. Now, as a practicing lawyer, anytime a lawyer, and particularly an academic, says, look away, there's nothing to see here, it gets my antenna way up. So I did some research, which can be found in the brief that I filed in advance of today. It sets out the path to prison on this. I knew as a commercial litigator that anyone can end up in jail if you breach a tribunal order. It is a simple civil contempt of court process. People go to jail for this. But what about the freedom of expression issue? It's a foundational issue. We all know that Section 2B of the Charter sets out that everybody has the fundamental freedoms of thought, belief, opinion, and expression. And we all know that the government has successfully restricted freedom of expression over the years. But what if rather than restricting what you can't say, the government actually mandated what you must say? In other words, instead of legislating that you cannot defame someone, for instance, the government says when you speak about a particular subject, let's say gender, you must use this government-approved set of words and theories. The American jurisprudence clearly defines this as unconstitutional compelled speech. In Canada, the Supreme Court has enunciated the principle that anything that forces someone to express opinions that are not their own is a penalty that is totalitarian and as such alien to the tradition of free nations like Canada. Now, how does C16 get us to compelled speech? The Minister of Justice has summarized Bill C16 as the enactment amends the Canadian Human Rights Act to add gender identity and gender expression to the list of prohibited grounds of discrimination. The Department of Justice website used to say that we must look to the Ontario Human Rights Commission policies for definitions on these terms. Ontario's policies on gender identity and gender expression are set out in my brief. They state that gender-based harassment can involve refusing to refer to a person by their self-identified name and proper personal pronoun. Refusing to refer to a trans person by their chosen name and a personal pronoun that matches their gender identity will likely be discrimination. The law is otherwise unsettled as to whether someone can insist on any one gender-neutral pronoun in particular. If the harasser didn't know or didn't intend to harass, it's still harassment. Now, why is this important? Well, in Ontario, the Human Rights Commission is a policy development creature of the legislature. It creates the policies which interpret the code. But what is most important, the tribunal must follow these policies. It is bound by them. So the Commission creates the law on pronouns. In Ontario, the policies on pronouns were introduced into the legal framework after the law had left the legislature. Federally, the same process will be followed as the Department of Justice had said so. A similar guideline will be developed. As with the Ontario policies, federal guidelines must be followed by the federal tribunal. The guidelines will mandate pronouns. This will happen after the bill leaves the Senate. Mandating use of pronouns requires one to use words that are not their own, which imply a belief in or an agreement with a certain theory on gender. If you try to disavow that theory, you can be brought before the Human Rights Commission for misgendering, or potentially find yourself guilty of a hate crime. To sum up, on the subject of gender, we're going to have government-mandated speech. Now, in opining on the constitutionality of the proposed bill, the Department of Justice said on its website, look, there's a variation to this bill that already exists in most of the provinces. I don't believe that's a robust argument in favor of constitutionality. I would refer you to the comments of the now Chief Justice McLaughlin of the Supreme Court in the decision of Taylor. It's in my brief. The chilling effect of leaving overbroad provisions on the books cannot be ignored, while the chilling effect of human rights legislation is likely to be less significant than that of a criminal prohibition. The vagueness of the law means it may well deter more conduct than can legitimately be targeted. As a lawyer on the ground, I worry about a poorly drafted law and its impact on my clients. As a Canadian, I worry about Parliament tacitly authorizing compelled speech. The brief I provided to the committee contains a comprehensive legal opinion that I published back in December on C16. There's a table that shows how the federal human rights regime mirrors the Ontario system in terms of enforcement of policies and guidelines.
You'll have to wrap up, sir.
And finally, it includes the case law that underpins the opinion. Thank you.
Okay, thank you both.
As a man in today's world, you can work incredibly hard, you can make sacrifices, and you can discipline yourself, and still never amount to much. My name is Hamza Ahmed, and I'm on a mission to help young men around the world to achieve success in all areas of life, from self-improvement to building a business that makes you feel powerful. And through Adonis School, I'm going to help you make your first $10,000 for yourself using the same step-by-step system that I've used to make hundreds of thousands.